Standish against Standish.
Lord Burrows will hand down this judgment.
On a divorce, the courts have wide powers to make financial orders so as to achieve a fair outcome between the parties. In leading past cases, it's been decided that while all the circumstances of the case must be taken into account, three principles should be applied in seeking to achieve a fair outcome. First, the needs principle, that the needs of the parties should, if possible, be provided for. Secondly, the compensation principle, that if one of the parties has given up valuable earning opportunities by marrying, there should be compensation for that loss. And thirdly, the sharing principle, that assets of the marriage partnership should be shared with the starting point being an equal division. The cases have also clarified that reflecting changes in social attitudes and working patterns, the courts will not discriminate in favour of the spouse who's been the principal wage earner at the expense of the spouse who has principally been the homemaker and, where relevant, child carer. This can be referred to as the non-discrimination principle. The case with which we are concerned is what has been termed a big money case. Without intending any disrespect to either, I shall refer to the parties as the husband and the wife. The husband is now aged 72 and the wife 57. The husband had a very successful career in the financial services industry. He acquired very considerable wealth. This was the second marriage for both the husband and the wife. They began living together in 2004 in Switzerland, where the husband was then working, and were married in 2005. They have 2 children together. Their marriage broke down in early 2020. The essential question in dispute is as follows. How does the sharing principle apply where, a relatively short time before the divorce, the husband made a transfer of assets worth some £80 million, I shall refer to them as the 2017 assets, to the wife for the purpose of setting up trusts to negate inheritance tax, and where at the date of the divorce the wife had not set up the trust and retains the assets. Mr. Justice Moore, at first instance, decided that the 2017 assets were what is termed matrimonial property and were subject to the sharing principle. But because the source of the 2017 assets was primarily the husband rather than the wife, he decided that the appropriate division should not be 50-50, but rather 60-40 in favour of the husband. Both the husband and the wife appealed to the Court of Appeal, which decided that the husband was entitled to 75% of the 2017 assets, plus half of 25% of those assets. This was because only 25% of the 2017 assets was matrimonial property and was subject to the sharing principle. The bulk of the 2017 assets was not matrimonial property and fell outside the sharing principle and was therefore ordered to be returned to the husband. The wife now appeals to the Supreme Court. She argues that the Court of Appeal placed too much weight on the husband being the primary source of the 2017 assets. She contends that, properly analysed, the transfer was effective as a gift to her of the 2017 assets. The Supreme Court unanimously dismisses her appeal. The leading judgment is given by myself and Lord Stevens, with whom Lord Reid, Lord Lloyd Jones and Lady Simler agree. There are several steps in our reasoning. First, the judgment examines the distinction between matrimonial property and non-matrimonial property. In general terms, this distinction turns on the source of the assets. Non-matrimonial property is typically premarital property brought into the marriage by one of the parties or property acquired by one of the parties by external inheritance or gift. In contrast, matrimonial property is property that comprises the fruits of the marriage partnership or reflects the marriage partnership or is the product of the parties' common endeavour. Secondly, the Supreme Court makes clear for the first time that non-matrimonial property should not be subject to the sharing principle, although non-matrimonial property can be subject to the principles of needs and compensation. Thirdly, the sharing of matrimonial property should normally be on an equal basis. Fourthly, and at the heart of the reasoning, what starts as non-matrimonial property may become matrimonial property through a process that was given the label in an earlier case of matrimonialisation. Although it may be new to the English language, the Supreme Court accepts that that is a useful shorthand term to describe the process by which non-matrimonial property may become matrimonial property. But whether one is using that label or not, the important question on any facts is whether that transformation has occurred. Although this has not previously been clearly spelt out, what is important, leaving aside matrimonial property resting on contributions from each party, is to consider how the parties have been dealing with the asset and whether this shows that over time they have been treating the asset as shared between them. That is, matrimonialisation rests on the parties over time treating the asset as shared. Finally, applying all that reasoning to the facts of this case, the Court of Appeal was correct that none of the husband's premarital assets, which were assessed as being 75% of the 2017 assets, became matrimonialised. This was because the transfer of the 2017 assets to the wife was to save inheritance tax and was for the benefit of the children, not for the benefit of the wife. The 2017 assets were not, therefore, being treated by the husband and wife for any period of time as shared between them. As the Court of Appeal therefore correctly decided, although the Supreme Court does not agree with all its reasoning, the husband was entitled to 75% of the 2017 assets, which was a non-matrimonial property, plus half of 25% of those assets, which was the matrimonial property. The wife's appeal is therefore dismissed.
The court will now adjourn.